Module 2, Part 2, inchoate offenses, or what's known as incomplete offenses. Incomplete criminal plans or schemes are punishable as a crime. They must occur in conjunction with other crimes or are defined by reference to other crimes. For example, robbery, rape, battery, murder, kidnapping, or arson. There are 6 stages to committing a crime. First, the person must conceive of an idea of committing the crime, then move to evaluating the idea, whether to proceed or not. Third, a person must form intent to move forward, then prepare to commit the crime. The 5th stage is commencing commission of the offense, and then finally, completing the act. The Model Penal Code defines attempt as when a person purposely engages in conduct that would constitute the crime if the intended circumstances were as he or she believes them to be. When causing a particular result is an element of the crime, does or omits to do anything with the purpose or causing, or with the belief that it will cause such result without further conduct on his or her part, is also defined as an attempt under the Model Penal Code. And then finally, an attempt occurs when a person purposely does or omits to do anything that, under the circumstances as he or she believes them to be, is an act or omission constituting a substantial step in a course of conduct planned to culminate in commission of the crime. For there to be mens rea of attempt, there must have a specified goal in place. Attempt as a crime requires specific intent to commit an act that, if it's carried out, would have resulted in a completed substantive crime. For crimes that are defined by prohibiting a certain result, there must be intent to cause that result. The actus reus of attempt is essential to the crime of attempt. An individual can't be held liable unless he or she has committed some act to further the plan to commit a substantive offense. Determining when a suspect has moved from preparation to planning is a challenge. The common law used what's known as the last act test. The attempt occurs when a person has performed all of the acts believed to be necessary to carry out the action that constitutes the underlying offense. The last act test is no longer used because most people believe a person does not have to complete the very last step to be culpable. Some other tests used in modern law are the physical proximity test. This is when the conduct has to be proximate or close to the completed crime. This could be the first or later step toward carrying out the crime. The dangerous proximity test is conduct that is in dangerous proximity to succeeding at the crime. There's no clear point when this occurs. It could be closeness of danger, significance of harm, and level of apprehension of the victim. Finally is the indispensable element test. No attempt occurs if an instrumentality hasn't been obtained. This particular test doesn't look at an individual's intent or their mental state. There are 2 more tests under the actus reus of attempt. The unequivocality test. This is where the individual's conduct and whether it was indicative of his or her criminal intent must clearly indicate that criminal intent. And a test from the Model Penal Code, the substantial step test, is when it is proven when an individual must have done or omitted to do something that constitutes a substantial test toward committing the substantive offense. This substantial step test requires strong corroboration of the individual's criminal intent. Some examples would be lying in wait, enticing the victim to a specific place, unlawful entry to where the crime is intended to be committed, possession of material specific to committing that crime, solicitation of an innocent agent to engage in conduct that is an element of the crime. There are some defenses to attempt. The first being impossibility. Was it a factual impossibility that the defendant is mistaken regarding some fact that it's critical to successful completion of the crime? For example, attempting to detonate a bomb with no explosives. This factual impossibility doesn't bar conviction for attempt if the mental state exists, the mens rea exists, and dangerousness has been proven. Legal impossibility is another defense. When intended acts, even if completed, would not have constituted a crime. For example, a defendant wrongly believes a person is a juror and offers a bribe. The genuine legal impossibility test is when the law doesn't define as criminal the goal the defendant sought to achieve. Another defense is abandonment. This is called renunciation by the Model Penal Code. Within abandonment, the defendant has the required mental state and has taken the necessary steps toward committing the act, but then changes his or her mind freely and voluntarily. This is controversial because it's easy to claim once the perpetrator is detected. And there are instances when the change of heart is genuine. The crime was actually wrong, and one of the parties involved has actually changed their mind. Another inchoate crime is what's known as solicitation or incitement. This is the act of seeking to persuade someone else to commit a crime with the intent that the crime be committed. This happens when someone advises, commands, counsels, encourages, entreats, hires, incites, instigates, invites, procures, requests, stimulates, or urges another to commit any felony or obstruction of justice or breach of peace. This exists if the crime has not been completed, attempted, or agreed to. It becomes a conspiracy when the solicitor and the solicited agree to commit the crime. It becomes attempt if the solicited attempts to complete the crime. There are some criticisms for the crime of solicitation. One being that the solicited is capable of making their own moral judgment to act on behalf of the solicitor. It's possible that the solicited will refuse. Another criticism is the solicitor is reluctant to commit the crime. Therefore, he or she is not a menace. And then finally, unsuccessful solicitation is far removed from societal harm. So punishment for the crime of solicitation comes close to punishing thoughts and intentions, which are prohibited under the First Amendment. The mens rea for solicitation is that there is a requirement that the solicitor have a mental state of desiring that the crime be carried out. Specific intent must exist at the time as the solicitor's communications for the crime to be complete. Speaking of words and intent in writing demonstrates mens rea for solicitation. Actus reus for solicitation includes a solicitor take any action, whether it be verbal or otherwise, to urge another to commit a crime. When coupled with intent, the crime is complete. This applies even when an intermediary fails to deliver information, materials, instrumentalities to the solicited. Abandonment is a defense to solicitation. Again, it's also known as renunciation of criminal purpose within the Model Penal Code. Under abandonment and this defense, the solicitor completely and voluntarily renounces his criminal intent. And the solicitor either persuades the solicited party not to commit the offense or otherwise prevents him from committing the crime. Conspiracy is another inchoate offense. Conspiracy is an agreement between two or more people to commit an unlawful act or acts, or to do a lawful act unlawfully, such as a partnership in crime. One of the parties must engage in an overt act. But there are some criticisms to conspiracy. The law is vague. It requires a defendant to do very little to be convicted. It punishes for a meeting of the minds with purpose of committing a plan. The focus is on mens rea, the mental state, rather than the actus reus, the physical act. There is some favor for the crime of conspiracy. It's an important tool for law enforcement against criminal enterprises. Criminal enterprises are a threat to society, operate covertly, and are difficult to detect and prove. The mens rea of conspiracy means that parties must have the intent to agree and the specific intent that the object of the agreement be achieved. It requires two or more people to be involved. Existence of the agreement is the actus reus and satisfies the first element of intent to agree. The question remains of whether knowledge is enough. The model penal code states, unless the conspiratorial agreement was made with the purpose of promoting or facilitating the commission of a substantive offense, you can't have the mens rea for conspiracy. Actus reus of conspiracy is the act of reaching the agreement. This is the advancement of the intent to further the criminal purpose, and advancement justifies involvement of law enforcement. Agreement can be proven by direct evidence, which is spoken or written word, or can be inferred from proof of conduct of the defendants. There must be proof of an overt act to prove the conspiracy is alive and at work. There are some defenses to solicitation and defenses to conspiracy, but the defenses common to attempt, like impossibility, is rarely used. There's strict requirements for the proof of abandonment of the conspiracy, and they must be met. And it must be an affirmative act or talks co-conspirators out of committing the crime.